Friends, today we are going to discuss the overview of the Contract Labour Regulation and Abolition Act 1970. First and foremost, what is the necessity of contract labour? The equation is very simple. There is a principal employer, there is a contractor, and there are employees of the contractor who are called as contract labour. Now you see, earlier contract labour, I heard it somewhere, I'm not very sure, that it existed even during the times of the Mughals. And the Mughals, in a way, they were only 200 families, but they gave contracts to different say Sardars in India. And say XYZ had an army of 5,000 soldiers. So he was made a Sardar, and those 5,000 soldiers were merged with the Mughal army. And then this army became huge, and this is the way they controlled India, are stories which I have heard, subject to correction. But the question is that during the 90s, say 70, the act is enacted. During the 90s, India slowly after 90s went on for privatization and liberalization. And there were so many foreign countries visiting India. Even today, Indian market is flooded with German companies, English companies, Czech companies, Swedish companies, all of them, Japanese companies. And then you see the work orders which we have, sometimes they are floating. Yes, I have opened up an industry and this is the quantum of work which surely I am going to get. So this is my workforce, so my manpower planning is, say 100 employees I am having for this much of work. And then God is very kind and God is very great, and suddenly I get a huge order. And what am I to do? So for that huge order, so it's an order which would cater to 130 employees. So 100 are already on my roll, so what about that 30? So those 30, I would put it on contract labour, because that order is itself volatile. It's a timely order, it's an ad hoc order, and tomorrow it may not be there. So you cannot expect an employer to have those 30 employees always on their rolls, because once they come on their rolls, they will be striving for permanency. And I cannot carry the dead weight of 130 employees for the rest of my life if I am an employer. For which this act comes to the rescue. Say 100 would be on my roll, that is the role of the principal employer. Then there is a contractor and 30 on contract, and after that work is over, they are supposed to go home, because they are contractual employees. So in a way, the equation functions this way. Now friends, who is a contract employee, a contract labour? Again, we have to understand this equation that there is a principal employer, there is a contractor, and there are contractual employees. I'll make it simple. I'll give you a simple analogy. See friends, we have all been in college. The main function of the college is to impart education, and there were students coming from different places, and then they used to be, they come early in the morning, and at 9 o'clock everybody wants a breakfast. So they requested the principal that yes, there ought to be a canteen. Principal also sympathetically understood their grievance, and ultimately they said that yes, there would be a canteen. But running a canteen is not the basic function of a college. The basic function of a college is to impart education. So what they did is they called for some tenders and appointed a canteen contractor. Now the canteen contractor has his own employees, the waiter, stewards, this one, that one, cashier, whatever. Now you see the equation again. There is a principal employer. The college has its own staff, say peons, clerks, whoever on their roles. Then there is a contractor, that is the canteen wala, the canteen contractor. And the canteen contractor has his own employees, that is who can be called as contract labour. So there is an intermediary between the principal employer and the contract labour. And it is this contractor who supervises the work of this contract labour. But remember, this equation is an ardent necessity. Without the equation, otherwise you don't require contract labour. And then the provisions of the Contract Labour Regulation and Abolition Act 1970 cannot come into picture. So this equation, understanding of this equation is a prerequisite to understand the Contract Labour Regulation and Abolition Act. today is a situation wherein this contract labor are facing, a pathetic state. Some even say that they have been granted a stepmotherly treatment. What is the necessity of contract labor is a concern which has been voiced by many unions. They said enough of this contract labor. Because if you see some unscrupulous, I am not painting all employers with the same brush. Some unscrupulous employers, what they have done is that they pay differently to their employees, that is the employees on the role of the principal employer, and the contract employees are paid less, minimal, hardly minimum wages, bare minimum wages, whereas for the same work, the employees on the principal employer's role are paid heavily. They have unions, they are organized labor, they have a bargaining power, their wage negotiation is strong. What about the contract labor? And contract labor in today's era, with the mandate of so many judgments, right from say Kalyani Steel's judgment, we have Indian Seamless judgment, we have Coca-Cola, we have a Cipla judgment, wherein the equation as it stands today is that there is a principal employer, there is a contractor, and there is contract labor. Contract labor, the employer-employer relationship is not between the contract labor and the principal employer after these judgments. So, in a way, some unions are voicing their concerns that you are giving a stepmotherly treatment to the contract labor, they are paid less. And moreover, there is no guarantee of employment. Just a phone call and you can ask some Tom, Dick and Harry from the contract labor to go home, and he does not have even a recourse to the court of law unless he raises a dispute, and these are long drawn out methods. And then and in the court of law, the employer files up all these judgments and pleads to the court that there is no direct employer-employer relationship between myself, that is the principal employer, and the contract labor. And yes, this is a fact also. And yes, friends, now this act is applicable where? This act is basically applicable to establishments where, say, 20 or more workmen are employed. Of course, you have to see the notifications again and again. Once upon a time in state of Maharashtra, it was more than 20 employees. Now it's 50. This can change also. So it's always in the fitness of things to see the latest notifications. Now, friends, when you see the Contract Labor Regulation and Abolition Act, you have to understand that every employer must be having a registration under Section 7 of the Contract Labor Regulation and Abolition Act. If at all the requisite number of contract labor is available on the rolls of the contractor, as per whatever is the notification in your respective states, say in state of Maharashtra it is 50, then the contractor ought to be having a license under Section 12 of the Contract Labor Regulation and Abolition Act. Now, between the principal employer and the contractor, there ought to be an agreement. And if any of these three things are missing, there are n number of judgments of the apex court which state that this is a sham contract. And once the contract is sham or declared as sham, the employer has taken not a small risk, but a huge risk, because the risk is all the contract labor can be asking for a permanency or to be on the rolls of the principal employer. Of course, friends, needless to say that one more aspect of it is that the same contract labor is continued 1 year, 2nd year, 3rd year, and years together. In that situation, what is the object of the act? It is Contract Labor (Regulation and Abolition Act. So first the contract labor is to be regulated, and then it is to be abolished. And the power to abolish contract labor is of course not with the courts, it is with the appropriate government under Section 10 of the Contract Labor Regulation and Abolition Act. Well, friends, the contractor is also to provide some amenities, say such as canteens, restrooms, provided the requisite number of employees are there, then clean drinking water, facility for latrines, and all of those which have to be provided. Now you see, many a times it so happens that the principal employer makes a payment to the contract labor. How? He can only make it through the contractor. And then you have the Contract Labor Act read with the contract labor rules, of which Rule 25 states that when the principal employer gives the payment to be made to the contractor. Contractor pays it to the contract labor. At that point of time, the representative of the principal employer ought to be present. Many a times, there are many instances wherein it has so happened that the contractor has not passed on, say, whatever are the emoluments to the contract labor. And the contract labor in that instance go and file cases against the principal employer. And of course, if at all the contractor has not paid it, it's the prime duty and the onus lies upon the principal employer to make good the payment. If at all he needs so, or if he finds it fit, he can reimburse it from the contractor, which of course is going to take donkey's years. But then that is for the employer to decide, and that is why he takes a huge risk by not ensuring or not keeping an eye over or not supervising the contract itself. There have been many employers who have found themselves in tight corners. Moreover, especially when the contractor has not even paid the statutory dues. He is not paid ESI dues, he is not paid Provident Fund dues. And then the Provident Fund Act comes into picture. And the paying of Provident Fund is one component. What about damages on the non-payment? What about interest on the non-payment? And plus that hanging sword of a penal provision. So all these things have to be looked up into one bag when we see the overview of the Contract Labor Regulation and Abolition Act. Now many a times there have been certain attacks on the principal employer that the contract labor, they are engaged in what? The work, if at all it's a perennial work, perennial means going the year around. And if the work is perennial, why do you want contract labor? Why don't you take some more employees on your permanent role if it's a perennial work? And that's why the dichotomy is between these two words, perennial work and ad hoc work. Ad hoc means for the time being, whereas perennial means for around the year or the full year, or maybe still years together. So it could be this way. And then the second is whether the work is incidental or it is necessary for the work of the establishment. If it is an ultimate necessity that come out this way, the establishment cannot function without these people, then why should there be a contractor and an intermediary? This is a question which has been asked by n number of courts. And lastly, friends, there is one more question to be answered. In similar establishments, whether such type of a work is done by regular workers or by contract labor, what is the practice in the industry? That also is to be seen. So a holistic view is to be seen. You cannot see, you cannot look at a niche area. You have to see the whole picture. You have to see, and that's why a holistic approach is very, very necessary. Now, if we take a bird's eye view, friends, of the total picture, initially the intention of the legislature is that it's not that the legislature intends to give a stepmotherly treatment to the contractor. It is to solve the exigencies of such type of work. There should be something on some scheme wherein, say, otherwise the only aspect would be that the moment I have work, I appoint employees, take on my permanent role, and then these people go and file permanency cases against me, and then ultimately there is no contract labor. This would ruin many organizations. It would be, the economy would be in a shambles, and then the total economy of the company, the economic health of the company would be in the waste paper basket. And ultimately, who is to take the risk? It's the employer who takes the risk. There are bank loans to be paid. There are payment schedules to be met, suppliers, so many things. And then for a momentary up and down, you cannot expect him to employ some employees as contract labor for the rest of his life. No. And that is why this scheme of contract labor is there, which is, in a way, in the words of some judge, it's a safety valve sort of a thing. That yes, there is work, I cater to the work, earn a profit, employ people, pay the people, people go home. That is contract labor. Everybody cannot be taken on the principal rule. And friends, at last, but not the least, there have been many cases on contract labor. Steel Authority of India case, Hussein's vice cases there. Standard vacuum cases there. Likewise, they are old and new cases. Coming to the new ones is the Indraprastha gas case. Likewise, but I am not going to just cite names here. because we are going to come with henceforth with many videos, some especially on cases, and then every detail and every aspect of the Contract Labor Regulation and Abolition Act 1970 would be discussed. Thank you so much.